Hi, everybody, and welcome to week 3 of our summer session 2 Civil Rights and Civil Liberties course. Believe it or not, we're almost at the halfway point now as I'm recording the voiceover this Sunday morning. So this week we're going to cover the Second Amendment and gun control. And just to briefly review the agenda, remember in this week's folder to look at how I'm asking you to look at the instructions to the individual project that's worth 20% of your grade. It's not a paper, it's something different. You can read what it's all about. I thought it would be a little bit more manageable than throwing a paper assignment in there. And it's not due till August 12, but please start working on it ahead of time and break it up into chunks. You'll notice one of your questions in the weekly test this week is my asking you at least to tentatively choose an idea and a format. You'll see that you can either do a PowerPoint with voiceover like I'm doing right now, but it'll be much shorter because you only have to tell me 5 things, or a fake TikTok using this app called Flip, which used to be called Flipgrid, or making a mock protest poster using an app called Canva. So you can read through those instructions that you see linked on the side on the Blackboard shell and let me know if you have any questions. Turning to the controversy. There's certainly more than one type of controversy when we're talking about guns and gun control, but what I'll first address is the legal controversy, and as far as the social or moral controversy, yes, some of that is involved in the legal controversy, but we'll be mostly focusing on constitutional law type of stuff and sort of, pivoting to talking about the more social or moral aspect of things later on. So just to let you know that. And the actual wording of the Second Amendment is right there in Bullet 3 in bold print. You might be surprised to see such a short amendment has caused so much controversy. And the Second Amendment states, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So, some of the most obvious legal controversies that have come out of this wording historically is, you can see there I have under bullet point 4, not be infringed. Does that mean that you can have no gun control laws at all? Well, it depends on who you ask. To some people, that wording should be taken literally, shall not be infringed. And they think there should be no gun control laws at all in any way, shape, or form, and that if there are any, it's a constitutional violation. That isn't the majority of people who are experts in the field of constitutional law. Most constitutional law experts would say you can have some gun control laws because not be infringed can't be taken that literally. So, for example, we have the First Amendment and freedom of speech, but as the famous saying goes, I can't yell fire in a crowded theater because everybody would get trampled in a big panic because my right to speak ends when somebody else's potential to being physically harmed begins. So, most people would say, well, yes, you can have some laws. It's just, how many laws can you have? And those laws can be as simple as just having to register your guns or saying that civilians can't own machine guns. And these are things most people would agree with. But then you get into more of the controversial things about banning certain types of weapons in certain types of areas, age restrictions, restrictions on ammunition, on certain classes of people, such as felons and things like that. So let's look at some of the more basic things and then we'll get to more details. The two main debates or interpretations is whether or not the First Amendment, choice one here, gives individuals the right to bear arms. So that would be you, that would be me, us individuals, or whether it only gives militias the right to bear arms. As far as which interpretation prevails, regardless of your political philosophy, as far as what the Supreme Court says, there's a very clear trend where they're saying that it gives individuals the right to bear arms. So, intelligent people could disagree with this interpretation, but that's what we're dealing with right now as far as the Supreme Court of the United States. And I'll tell you a little bit about how we got there. So, as far as what a militia is anyway, it's good to know what is and what isn't meant by a militia. So you see these guys here that I'm wiggling the mouse over. That's a picture I just got offline to show you an example of a modern day militia. That's the New Jersey militia. If you want to look at an old-fashioned militia, just search up a picture under Google Images of the Battle of Lexington and Concord, and some of the militiamen, the Minutemen, were part of what was referred to as a militia at that time. So our modern day definition, which is from a good source, you can see I cited down bottom, is that it's a group of able-bodied citizens who organize themselves as a separate non-governmental group who stand ready, willing, and able to supplement the U.S. Armed Services if necessary. Historically, militias are also seen as a way to keep the government in check to ensure it doesn't try to establish a tyrannical government over its citizens. So you have these little independent groups like the New Jersey militia. There are several in New Hampshire. And most of them are, well, I should say arguably most of them seem pretty legit. There are some fringe groups that should not be confused with a regular militia. There was some group out in front of the Kittery Trading Post this past week that had some white supremacists in the group, and they're passing out really racist leaflets, and they were trying to say they were some kind of militia, and they were wearing army fatigues, but journalists investigated, and they have no organized militia activities except posting a bunch of stuff online that's hateful. So anyway, just know that militia is not interchangeable with the word military, although some researchers have said that the Coast Guard, the National Guard, could arguably follow under this definition. But the word militia is not interchangeable with the Army, Navy, Air Force, and Marines. So some other basic interpretations before we get into the cases that have been passed by Congress and the, laws that have been passed by Congress and cases that have been interpreted by the Supreme Court. Before we get to that, let's look at some other interpretations, because your mainstream American doesn't have an extreme position on gun control. If you do research, you'll see that it's like abortion or the death penalty, right? Most people do not have extreme political philosophies on this issue. Most people don't think that the death penalty should be banned even for serial killers. Most people think it should be allowed in certain extreme situations. And then, you get into other statistics about for and against. Just like most people do not believe abortion should be banned in every single circumstance, including rape, incest, and life of the mother. So most people don't have extreme views on gun control either. You can find all kinds of research that says all kinds of varying things. And if you've taken research methods or have been, around long enough, you know that you can play with statistics. But if you look at enough research from vetted sources, you will find that most individuals believe in some sort of basic right to bear arms. But they believe in basic restrictions like that you should have to have a background check and not be a felon and, not be allowed to carry on around a machine gun. But you get into the debates is over things like whether the age should be 18 or 21, whether AR-15s, assault rifles should be banned, or whether you should have no firearm zones and things like that. You still do also have these alternate perspectives that are very extreme, but those don't make up a majority of the population. As far as the people who think that any gun control laws are an infringement and can lead to a slippery slope of fascism and point to Nazi Germany, for example, well, I can't argue with somebody's philosophy because that's their belief. But as far as pointing to Nazi Germany as an example, if you look at some fact check sites that you can use, like PolitiFact and I want to say it's factcheck.org, not com. But in any case, those are good sites. And, they had tons of gun control in Nazi Germany before Hitler, just like they had tons and tons of gun control in the Wild West. You'd ride into one of these towns, and right at the town border, the sheriff would hold your firearm while you shopped or visited or whatever. So there's a lot of fact versus fiction that you can get involved in this regard. Now, what political generalizations do we draw from those interpretations, and why is it even important to draw those political generalizations? Well, first off, traditionally, liberals and Democrats, they'd argue for more gun control, and conservatives would, generally speaking, argue for minimal gun control. But there are always exceptions to these stereotypes. I have known quite a few liberals that are against gun control, and I have also known some conservatives who are for it. And there are statistics that help, flesh that out, that it's not an anomaly. It's not just anecdotal. If you know somebody along those lines, there's a statistical minority in both of those things I just mentioned. So the reason why those stereotypes matter is because we have different waves of certain types of political thinking, where that certain types of political thinking becomes more popular, or at least more popular among those people who are in institutions of power, and it can eventually affect what laws are made. Another thing to look at is the good guy with a gun argument. There was recently a case at a shopping center in, I forget the name of the state the shopping center was in. If you know, put the name in this week's discussion board post. But there was a good guy with a gun who helped stop a mass shooting. And that's a great thing. The only thing is that only happens a minority of the time. Things usually don't play out that way. And sometimes there are people who have no criminal history at all, who you would think would be a good guy, that end up being a perpetrator. The other thing is that in cases like what happened in Uvalde, we had not only good guys, but a bunch of armed and trained police officers show up who stood outside the room for quite some time while that school shooter was taking more lives. So there is a good guy with a gun argument. There are plenty of anecdotes you can find online, but that is anecdotal evidence. As far as broad-based statistical evidence, in states that have very few gun control laws, you don't find an abundance of these good guys stopping crime. And when people try to bring up statistics such as, this is what happens in a state that has lots of gun control, and this is what happens in a state that has the opposite, the statistics are all over the place, and sociologists draw different conclusions. The only one that's really common is that there isn't a lot of cause and effect relationship as far as stopping crime, but there is as far as reducing mass shootings. and reducing overall raw numbers with gun control. When it comes to actions our lawmakers have made, the courts and Congress will first cover Congress and the 7 main federal laws. There's a ton of state laws, and we won't even have time to touch on those. And we won't even, have time in a 6-week course to go into detail about all of the federal legislation. These are just the 7 main laws. And as you can see, back in 1934, there was a federal law passed that said that Congress was going to tax transfers and sales of firearms, and that you had to register your guns, which was controversial at the time. There were some folks who thought that if guns could be registered, then that could lead to the government taking everybody's firearms away, which has not turned out to be the case. And that's why you'll hear in some crime shows where somebody saws off the serial numbers or saws off the registration numbers of a firearm. And that happens when a firearm gets stolen and it goes into the black market of stolen firearms. And then somebody saws off that number literally with like a rough metal file, so it can't be traced and it can be continued to be used for criminal activity. The second major law was passed in 1938 that said that gun dealers actually have to be licensed, and there's a certain criteria for that, and that sales to felons were banned. Later on in 1968, Congress passed a law that said firearms transfers couldn't happen interstate, in other words, from one state to the next, except by licensed manufacturers, dealers, and importers. Because remember, a state can regulate gun laws that happen within the 4 corners of the state, so to speak. Like Massachusetts, for example, has really strict gun control laws, which we'll talk about later on. That's going to be an issue. And Texas does not have very strict gun control laws. But when things happen between states, that's when the federal government can step in, and they had this law come down in 1968. There was also the Firearm Owners Protection Act of 1986, which had some parts that gun control people liked and some parts that gun enthusiasts liked. So it allowed for this safe passage clause where, for example, if I was somebody who was trying to transport a firearm legally and safely from one state to another, before this act was passed in 1986, they used to actually have these guidebooks that would tell you how to do it and not get into trouble in any of the states you are passing through. Because what if they had a different regulation about having it locked up in the trunk or locked up in a case, or you couldn't have a certain type of firearm? This safe passage law said basically if it's contained in a way that was legal from the state you exited from, and you're passing through the state, then it's legit during that time of travel. The 1986 law also confirmed the ban on machine guns by civilians. It banned the government from trying to compile some sort of master list of people who, owned certain types of firearms or owned firearms at all. Certain civil libertarians were afraid of that. There were some allowances for certain types of ammunition to be sent through the mail. And another part banned sales to not only felons, but somebody who was being in the process of being indicted for a felony until the matter got resolved, fugitives from justice, and some other miscellaneous categories. So there were some wins and losses for both camps on the gun control debate side. As far as the remaining gun control laws, we had the Brady Act of 1993, and that got passed a little while after President Reagan was shot by John Hinckley during that attempted assassination, which failed. I'm sure most people know Reagan did live. One of Ronald Reagan's associates, Mr. Brady, was standing by him and was shot and ended up having to use a wheelchair. And so the Brady Act was passed later on after some gun control advocacy by a variety of groups. And this resulted in mandatory background checks for anybody trying to buy a firearm, a 5-day waiting period so that background check could take place. And then what ended up happening is when we got this NICS system, this InstaCheck system implemented, they kept the background checks, but they did away with a 5-day waiting period because that brought up certain constitutional law issues with the right to bear arms, and it wasn't necessary anymore. It confirmed sales or banning of sales to certain categories of people, and it also recognized that states could have additional regulations. There was a loophole that was called the gun show loophole, where, because of the wording of the Brady Act, people who are private individuals or not dealers at a gun show could sell guns to each other, and that loophole is in the process of being closed, supposedly. We also had the assault weapons ban of 1994, and that expired in 2004. It was one of those laws that was so controversial that in order to get it passed, Democrats agreed for it to have a sunset provision or a shelf life. In other words, it would only last 10 years. And that banned assault weapons. That law is no longer in effect. And there's some controversy about what constitutes an assault weapon. Most people think of AR-15s and AR-17s or things that look like those as assault weapons. But there's no standard definition as far as the gun industry calling a certain type an assault weapon. So it's not just machine guns, although machine guns could be considered assault weapons. Pretty much nobody can own them except for the military. AR-15s and 17s are legal now, and part of the controversy is that there are some, for example, hunting rifles. If I were to show you a picture, that you would say that's not an assault weapon, that's something that a cowboy would carry in a Western movie, an old-fashioned Western movie, that actually have more firepower and can do more damage than an AR. The problem is, and I'm saying this from the perspective of somebody who, my dad, before he passed, was a certified firearms instructor and trained me to use firearms. And I actually, at a certain training, because he used to help train police officers, got the chance to target shoot with, I think it was an AR-17. And the problem is that they're so user-friendly that pretty much any idiot with minimal training could pick one up and use it, and with minimal training do a whole lot of damage very fast. However, with a hunting weapon, there's a huge learning curve. You kind of have to know what you're doing. There's a lot more kickback. The sights on it are harder to use. And there's a whole bunch of other stuff. But long story short, the AR-15s and 17s, you don't really have to have a lot of firearms expertise to do a lot of damage. And so that's why Congress, focused on the ARs and not hunting rifles. And there were other reasons why they didn't. But that's part of the controversy. Parts of Congress have been trying to reinstitute the assault weapons ban and haven't had any luck. What they have had luck doing is passing the Bipartisan Safety Communities Act of 2022. And this was a compromise bill, and it provided a whole huge jackpot of money to states that they can get money from, that they can create systemic change to try to keep guns out of the hands of mentally ill people and substance abusers by creating drug courts and similar courts. In other words, treatment courts that get to the root of the problem. They also closed the boyfriend loophole, where previously there was legislation that prohibited people who were guilty of or currently charged with a domestic violence charge could not get a gun license and or could get their, if they were in the process of doing it and they did the check, they would see the pending charge and say, come back when this is resolved. And what happened was people who were not married were able to, get a firearm anyway in certain circumstances. Say the charge wasn't a felony, say it was a misdemeanor, it wouldn't show up. Or say the person went to get a restraining order. A lot of times an automatic part of that in states is to honor a request from the plaintiff to, at least for the time being, take the person's firearms away. And some states, they didn't allow that unless the parties were married. So the boyfriend loophole closed that. It clarified who firearms dealers were, the rules that needed to be followed. It enhanced the review process for buyers under 21. It enhanced penalties for straw man buyers. So I would be a straw man buyer if I went and purchased the firearm for somebody else because the other person couldn't do it because of charges or being underage. And then a whole bunch of money for general community violence prevention programs. So nothing earth-shattering. It was really sort of legislation that sanded down the rough edges of some non-controversial legislation. So we didn't get any new assault weapons ban or anything else that some gun control advocates wanted, that wasn't done. So as far as gun control cases, there are more than these 5, but there are the major 5 right here. And we'll start off talking about U.S. versus Miller. But one thing to keep in mind is that even if I were to include, cases that weren't as significant or earth-shattering that only touched on gun control, we probably only have about a dozen cases. And if we're looking at something like the First Amendment, you have hundreds of cases for each different part of the First Amendment, like hundreds or thousands of cases about freedom of speech, hundreds or thousands of cases about the Establishment Clause. So there aren't that many when it comes to the Second Amendment, which some people have found curious. But in any case, back in 1939, there was a case of U.S. v. Miller, and we have a picture of the dapper Mr. Miller there. And essentially, Mr. Miller and his companion were charged with carrying a sawed-off shotgun. And if you don't know what a sawed-off shotgun is, it's just what it looks like right there. And it looks short because they sawed the end off. And if you're wondering why somebody would want to do that, if you saw off the end of the barrel of the weapon, then you get more firepower and it can do more damage. So usually if somebody's sawing off a shotgun or a revolver or a handgun, most of the time that's indicative of criminal activity. And I don't know if these guys were running moonshine or something. I don't know what was going on. But in any case, the Supreme Court had to decide whether or not a specific law that banned the right to carry a sawed-off shotgun, whether that was allowed by the Second Amendment. And the Supreme Court said yes, that is legitimate, and the Second Amendment does not prohibit that. So it seems not that monumental to us, but this was the first big gun control case, so to speak, that the Supreme Court decided. It was kind of earth-shattering for 1939 to, approve of this law and not strike it down. In 1980, you had a petitioner by the name of George Calvin Lewis, and he was convicted of a felony in the state of California for breaking and entering with an intent to commit a misdemeanor. I'm going to have to check that commit part, as well as the date. But in any case, he tried to purchase a firearm many years later, and he couldn't do so because of this prior conviction. and he challenged the California law, but he lost in front of the Supreme Court. So the Supreme Court will uphold a state law that bans felons from owning any firearms, even if it's some years later, even if a state says, once you've had a felony, that means you can't ever own a firearm. So, back then that was considered pretty consequential. Now we're getting into some more recent cases. I know 2008 isn't very recent, but as far as talking about constitutional law type of stuff, it's pretty recent. So the question presented was, does this restriction that was instituted by the District of Columbia, does it violate the Constitution? And this specific Constitution was considered kind of quirky or unusual by most constitutional law experts, because first of all, D.C. is a district. It's not a city or a town, and it's not a state. It's sort of its own quirky little entity, right? D.C. And it's a high crime area. The one and only time I was ever mugged was in D.C. And it restricted the licensing of handguns, had tons of restrictions. And when you kept the firearm at your house, it had to basically be taken partially apart and be in a non-functional state. So people who procured a firearm for the sake of, safety in their home were saying, well, what use is it? Because, these same Second Amendment enthusiasts would point out that there are certain types of safes where you can keep a firearm out of reach of your kid, but they have technology where you use like a thumbprint or a handprint to open it up, or it's a really quick, 3-digit combination or something like that. But if you have to put a firearm back together, if you're trying to protect yourself or your home, it would be too late. So in any case, this restriction, this law was brought up before the Supreme Court, and the Supreme Court struck it down, saying that it was unreasonable. And in doing so, they said that the Second Amendment doesn't just apply to state militias, but it applies to individuals also. And this quote was a big victory for the NRA, the National Rifle Association. They're a supposedly public interest group, but not everybody would consider them that. They're a pro-gun rights group. And they really like this ruling for obvious reasons. And they indicated, the Supreme Court indicated, therefore, banning handguns, an entire class of arms that is commonly used for protection purposes, and prohibiting firearms from being kept functional in the home, the area in need of protection violates the Second Amendment. So this is, a big loss for people that are in favor of gun control, because it's different than the Dobbs v. Jackson case we talked about last week. Dobbs v. Jackson was a case where the Supreme Court said, we're going to leave it up to the states because we can't find anything in the Constitution on this issue. This is different because the Supreme Court is saying, yes, we can point specifically to one area, and you can't make laws like this. You, meaning not just Congress, but in the plural form, as in like ustedes, like you can't, as in the states also. And that was language that was hinted at, and as far as it being applied to the states. But that's the way it was interpreted, along with the right being applied to the individual. Any ambiguity about whether or not that these guarantees apply to the states and this right being incorporated was, any doubts were cast aside in 2010 with McDonald v. Chicago. And after the Heller decision, gun owners filed cases against the city of Chicago, which we know is a high crime city. And it's a high crime city at periods of time when you've had no gun control, at times where you've had tons of gun control. It's a unique atmosphere unto itself. But anyway, they had an ordinance that banned handguns. And the Supreme Court struck down that city municipal regulation based on the Heller case. And additionally, they said not only does the Second Amendment apply to individuals and not just militias, but this amendment is incorporated. So in other words, it also applies to the states. So the total ban on handguns was removed, and now you can even get a concealed carry permit, but not an open carry in Chicago. So open carry is so that people can actually see your firearm. And the advantage to having an open carry law, some would say, is that law enforcement and others at least have noticed that you are that you are carrying a weapon. But what was confusing is for many, many years after 2010, states like Massachusetts still had tons of gun control, even though you had this Heller case and McDonald case, and nobody can give you an answer about exactly why that is, except that nobody's brought up those particular laws in front of the Supreme Court. And even Massachusetts doesn't have like a ban on handguns, They just make you jump through a lot of hoops to get your license. And, they do have bans on certain other types of firearms. But in any case, experts say that the Supreme Court would only step in, or gun owners' advocacy groups would only push the issue if there were bans on everyday firearms like handguns. So that brings us to the most recent 2022 case, New York Rifle and Pistol versus Bruin. And New York had a law that required people who wanted to carry a concealed weapon to show special need and proper cause. And I would imagine if you looked up the legislative history of this, that the reason why Congress wanted to do this is because, one reason could be because those in the law enforcement community didn't want everybody and his brother having a firearm, that they wanted to reduce the number of people who had concealed firearms, I should say, and that people who were allowed to get them would be thoroughly vetted. But the Supreme Court said that New York's rule that you have to show a special need or a proper cause, that it violated the 14th Amendment by preventing law-abiding citizens with ordinary self-defense needs from exercising their Second Amendment right to keep and bear arms in public for self-defense. So the important quote was, "The right to carry a firearm in public for self-defense is deeply rooted in history, and no other constitutional right requires a showing of special need to exercise it. While some sensitive place restrictions might be appropriate," and just to let you know what those might be, is inside like a huge concert venue, or certain public places like going to see the president give a speech. Manhattan is not a sensitive place. Gun restrictions are constitutional only if there is a tradition of such regulation in U.S. history. So, very controversial, because one thing is there's a whole bunch of tradition of gun controls in certain areas and certain categories. States like Massachusetts have a process where long ago, when I had my license to carry, which I no longer have anymore because I don't work a high-risk type of job in the prosecutor's office anymore, and I have a child in my home. But back when I had one, I had to go in front of the police chief, and you basically have to go through your local police chief. It's kind of like up to their discretion whether you can get a firearm or not. So it seems as though somebody could challenge that. But in any case, that brings us to where we are now. And some states, like Massachusetts, as I said, will probably have to revise their gun control laws because the court rulings have gotten even more clear. And there are plenty of gun owners' rights groups in Massachusetts, and perhaps even the ACLU will help them challenge it. States like Texas, their laws are most likely already in alignment with all of these Supreme Court cases. And if you want to see a state-by-state comparison, it's pretty wild how different things can be one state to the next. I do have a link there from the Gifford Center if you're doing your individual project on the Second Amendment, that might be a good site to look at. And before we had the conservative supermajority on the Supreme Court, and the reason why it's gotten that name is because there are so many people from one political affiliation. You have 6 out of the 9 that are very conservative. Before we had that supermajority, some seemingly contradictory laws were allowed to stand, but now we're probably going to see some challenges. So we're seeing some more emerging arguments that would say, why are we still clinging on to constitutional arguments that, shouldn't be our primary focus? And these arguments about not focusing on the Constitution could be part of what some are calling a constitutional nullification argument. So folks who believe in this constitutional nullification argument would say, why are we relying on words that were written 230 years ago by men who owned human beings and would be scared of our microwave? Why are we relying on them to make laws that are relevant today, especially when there's a huge societal problem that has emerged, like the mass shootings and the school shootings, which are curtailed by not overall crime, but the mass shootings are curtailed by things like assault weapons bans, most research shows. So there's an emerging argument that says, we're going to be seeing a showdown that, over time, sometimes constitutions get removed, amended, revoked, reworded, that we might have to revisit the Second Amendment if the way it's written right now is being interpreted the way it is being interpreted right now, which is not in line with what the majority want. And not that you always want to go in line with what the majority of people want, because back in 1954, when Brown versus Board of Education was ruled on, the case that integrated the schools, the majority of the folks were so racist that they didn't want that, right? So I'm not saying that the Supreme Court should automatically, do what the majority of people want. But when it's combined with a public safety issue, and it's combined with what many argue is a moral, issue that needs to be addressed, then perhaps that it's worth a conversation. So in this week's discussion board post, you'll be asked about your thoughts on the Second Amendment, which interpretation you want, and your thoughts and things like that. Because right now we're stuck with what we have, and we would have to either change the makeup of the Supreme Court by the controversial act of adding more judges that some people have proposed, so they're reflecting the will of the people more. It's pretty controversial. Or, getting together and seeing what needs to be done to reword or revoke the amendment, which, can be very challenging because we've been trying to pass the Equal Rights Amendment since 1972-73, and it hasn't happened yet. So you'll have a chance to share your thoughts on that in the discussion board. All right, thanks so much.